Ladies and gentlemen, this session is now live on YouTube and the inspector is about to join us. Inspector, welcome back to the session. I can confirm you are live on YouTube.
Right, just waiting to see whether everyone's available. I mean, I did say I didn't exactly give a specific time. I just said 15-minute adjournment, but for resumption. So I'm assuming that some people haven't actually joined yet. But I'll wait to see whether Mr. White is joining. And right. So I think Mr. Hal Williams, are you saying something, or because you're on mute? But
sorry, sir, I was talking to myself.
Oh right, yeah, that's all right. No, yeah.
Ms. Foster, is Mr. White QC about to join us?
Yes, I think so.
Right, thank you. All right. Yeah, sorry, Mr. White. I didn't make it clear where I just said 15-minute adjournment. Not. I'm assuming you expected it to be 11:15.
I will admit, as I'm getting timing so badly wrong today, I will admit I did make that assumption. 11:15.
Yeah. I'm sorry about that. I should have made it clear.
No, don't worry. So
I've had a question from Councillor Crawford about asking questions of witnesses. I prefer not to have off-the-cuff questions, otherwise we end up in a bit of a disagreement all the time. But if people do have, if those people who've actually given statements to the inquiry, if they've actually got in their statement something that mentions a specific matter to do with one of the witnesses that are coming up, it would be helpful to me and everyone else if they can give the programme officer an indication that they would like to ask those witnesses a question or several questions or whatever, and an indication of how many questions. This isn't trying to open it up to too many people or to a lot of people. And I'd like to emphasize that the questions really, if they've already been asked by the council anyway, there's no point in asking them again. So, but if you've actually got a specific question that you want to ask, which is related to your evidence, i.e. you've already mentioned these matters in your evidence and you'd like to ask that witness, it's worth letting the programme officer know before the witness comes, is heard, is actually giving evidence, so that I know who's going to be asking questions or who wishes to ask questions. And those questions, like I say, will be after I and Mr. and the council's advocate will have asked those questions. So hopefully we will cover most of the matters that people want to ask questions on anyway. But certainly, if there's something that hasn't been asked and someone feels that's necessary to be asked, it's helpful to know in advance that someone wishes to ask those questions. So I'll hand over to Councillor Crawford just to see what he'd like to say. Yes.
Yep, thank you, sir. That's very clear as far as asking questions of witnesses. So I appreciate that. When you have roundtable discussions, can you just explain what process you'd like to follow if I wish to make a contribution?
Right. I think on roundtable discussions, it's more awkward because I don't really want to have too many people involved in a roundtable discussion, because otherwise it gets to quite a difficult position. But if you've got something you'd like to raise, you can certainly put your hand up and raise it. But I prefer it if it's on this particular topic that we're dealing with and it hasn't been covered, and then before I move on to another topic or something like that. But I'm trying to keep a timetable that's quite difficult to keep at the moment.
Yeah, I do understand the challenge.
And so I'm trying not to diverge too far away from the topics, but and certainly it should relate to something that's been put in evidence by that person. So I prefer it. I mean, it shouldn't be that someone who asks a question or adds to a roundtable session hasn't actually put that in as their evidence, because otherwise it just ends up with people introducing new evidence that they'd never even mentioned. Okay. So that's the way I'd like to handle it.
I'll try and stick to your criteria as close as
right. If you, I mean, I know it's very difficult for people who aren't used to these type of procedures, and certainly not everyone handles them the same. But anyway, thank you, Mr. Crawford.
That's fine. Thank you. Thank you very much indeed.
Mr. Howard Williams has now got his hand up. I know we're very tight on time today. Mr. Howard Williams, you're muted. Yeah.
Yeah, thank you very much. So just very quickly, I would just like to ask through you that before we leave today, Mr. White can clarify, perhaps by reference to a note, if that's a more a quicker way of dealing with it. But I think we should be told what the illustrative master plan relates to in terms of the quantum of units. Yeah. I have done a little bit of investigation, and I found that there's a reference in the statement of case at paragraph 7.8.2 to unit mix as shown on the illustrative master plan, and a table below that which shows 141. The same message is given on page 40 of the design and access.
So in the interest of time, Mr. Howell Williams, they both show 141.
I'm very grateful. Thank you very much, Mr. White. Thank you.
Right, thank you. So if that can be taken on board then, Mr. White, when we come to that stage of evidence or whatever. But at the moment, I'd like to move on to the public right of way. And there is an agenda that I've put forward. It's really mainly to do with just points that have been raised. And so it's just a memory jogger really in terms of that. But if I can just go through the people who've actually said they'd like to take part. And so on my programme, I've got for the council, there's Kate Beswick, David Withicombe and Mark Davis. So are you all available? And for the appellant, I've got Mr. Ross, Marshall and Smith. So I think that's quite a lot of people for one footpath. But anyway, hopefully we can focus on just one or two individuals really. But if someone else has got something they'd like to say. So what I'll do is, like I say, I've got the this agenda, but I've also got the state. I might have even put this agenda forward before I got this statement of common ground. So I think on the statement of common ground, it states that it's disputed by the appellant about whether this will get confirmation or not. So what I'd like to first of all look at is about the confirmation of this footpath, AB 70, which I understand it will be put forward at an inquiry, will be subject to an inquiry in April. So I'd like to ask Ms. Bezic about her views on this confirmation and the route. I think I've got the route of this particular that's going to be put forward by Kent County Council for confirmation. So if I can hand over to Ms. Bezic.
Yes, good morning. The route of AB 70 came to us as a claimed route. KCC's view is quite clear in the sense that we've gone through the due legal investigative process. The definitive map team considered that the rights reasonably exist, and as such we have made an order to reflect this. On completion of this order, on the making of this order, one sole objection was received, which was from Waits Development and the landowners of this site. And due to this objection being received, as you say, it's now been subjected to put forward for a planning inquiry in April. I think the council's view is therefore quite clear that we do consider that these rights can be reasonably alleged to exist, and as such we've felt that we advised that the route should be shown on master plans at this stage, in order that if it was confirmed, then due process could take place in a timely manner to consider an alternative route.
And so if what are the implications if it's on the confirmation, if it's not, if this development is, say, allowed, say I do actually allow the appeal and this and planning permission is granted for this development as on the master plan, what is the impact on that order that's going forward? The confirmation.
Just before I immediately answer that, I would point out that all the authority report, order plan, etc., are within the core documents. So it's 4.6, which give the details of the investigation, and the order plan showing the route of AB 70 on a definitive map.
Right. Well, that's quite useful to have a look. I'll just bring that up. 4.6. So we're looking at the definitive map and state. So I'll look at the definitive map. Probably that's the best.
Yes,
way.
that shows the route that.
Yeah. Yes, that's
which
what
the order has been made.
Before. Yeah. So. Oh, hang on. That's not the right one. Hang on. Can you say which CD46?
CD 4.6 points A to D, I believe it is. I can just the definitive map 4.6A, then in brackets 3.
Yes,
that's AB. Sorry, that's AB 12. The delegated.
Yeah, that's AB 12. That's the one I was looking at. Yeah.
Sorry, 4.6.
Have AB 70 on. No.
4.6C, delegated authority report 3 AB 70.
Yeah. Now that's.
And then 4.6A in brackets 2, definitive mapping statement, KCC footpath AB 70.
Right, that's it. That's the one. Appendix A. Is that right? Oh, no. just wanted to, you said that's Appendix A to that report, is it, that shows?
That's the definitive map modification order, which
Oh, that's
the last page of which shows the definitive map extract.
Right, just want to make sure I've got the right plan up.
Yep.
So this is public rights. This is for decision, right? So you've got the proposal, legal test, the case, conclusions. Then you've got Appendix A, plan showing the claimed route and extract from the definitive map. Is that the one you're suggesting? Appendix
Yes.
A to that document, right?
Yes, CD 4.6A in brackets 2.
Yes, and that's Appendix A to that document, which is the plan, and that's AB 70.
Yes.
As proposed. Yes.
Yes.
Right. So that's the route, and so in terms of that, what is the impact that would have?
So
The route-
before we,
The,
so
what
can
is
I,
the impact of the order on that?
sorry, sir, I just wanted to make a point before you move on to that, just as a matter of.
So Mr. White, yes.
Yes, sorry, just a very small point, but it's not only important for you to look at the map, but also what's said in part 2 of the modification of definitive statement, because it clearly affects your next statement. And that is just to note, I don't know if you've noted or picked up what is actually sought by the county council, and that is the width is 2 meters between points A to D, reduced width of 1.5 at point B and 1.5 between point D and E. I'm sorry to bring this up, but it is material as you are about to ask the next question about effect. Just to note what is actually being sought in terms, obviously the width does have an influence on effect.
Yeah, yes, right, thank you. Right, thank you for raising that. So bearing that in mind, as Bezik, what is, so Mr. White's got his hand up still, I don't know whether, but anyway, what would the effect of this be? I mean, going back to my question again, what would be the effect of this development should it get approved on that order?
The effect of the footpath on the development, currently with no diversion, the footpath runs, as we know, through the western side of the site. It's on the original master plan, it would have gone through houses. On the amended plans, it is shown.
Sorry, can I interrupt? Now, what I'd like to know is, what if this was approved as it's being put forward with the plans that are being put forward, what effect would that have on the confirmation of this order at that inquiry?
There would be a detrimental impact on both the development and the right of way.
When you say detrimental impact, would it prevent that being confirmed?
I don't believe it's quite for me to comment on whether it will be confirmed or not, as it's subject to a separate inquiry.
What influence would it have on the confirmation of the order? I mean, is it something that would stop that footpath confirmation order being made?
No, because the public inquiry is to do with the merits of the route in the sense of evidence of use. It's not looking at it in terms of this planning development.
Right, so it's in terms of use, right?
Yeah, to consider whether public rights do exist. It's not to determine anything regarding this planning application.
And so if the order is confirmed, and you're saying that this, even whatever happens with this, this particular inquiry and what decision I come up with won't influence that. Is that what you're saying?
As I believe it, yeah.
Yeah. So if that's the case, sorry, I can't remember. If that's the case, it's not going to be influencing that. So if it is confirmed, that could still be accommodated, could it, into this development?
Sorry, I seem to have lost. Can you still hear me?
Yes, I can
Yep.
hear you.
Okay, thank you. Sorry, everything went blank for a second.
Oh, did it? All right. Yeah.
If the order is confirmed, we do believe that the path as has been proposed, the accommodation is not acceptable. It does not provide an alternative route. The plans that are shown in the Appendix G of Mr. Ross' statement were submitted in December. They weren't part of the application process. So they were received late into this, and they do not show an acceptable alternative route to positively incorporate the route of AB70. And they do not fit the criteria that we would be looking for to meet the standards that are expected of high quality public rights of way routes.
Yeah. Yeah. So that seems to be the main concern then, about whether whatever's going to be put forward by the appellant, whether they can actually put forward something that gives a satisfactory route if this is confirmed. And well, I think there's differing opinions as to the likelihood of it being confirmed, but certainly you're of the opinion that it is likely to be confirmed at the inquiry, because there's going to be evidence that the rights will actually be sufficient.
Correct. We believe at this stage, having been through the correct processes, that and the evidence has been gathered, that the rights do allegedly exist, and this, as I say, is going to public inquiry to be determined following the sole objection.
All right. Okay. What I'd like to do before I move on to how it affects this development, I'd like to just go to, well, I think Mr. Ross has got his hand up, so I was going to move on to the appellant to have their say on what you've just said. So, Mr. Ross.
Thank you very much, sir, and I hope you can hear me.
Yes, I can. Yes.
I've no qualm or question in terms of the procedural process that KCC have gone through, but Waits and the appellant are absolutely clear that the evidence that we have will demonstrate that the footpath will not be confirmed. And earlier this week, we submitted our statement of case to the Planning Inspectorate, setting out clear, unequivocal forensic evidence demonstrating why those rights do not exist, have not existed, and therefore that the footpath will simply not be confirmed. And all of this is hypothetical.
Mm-hmm. Yeah.
Yes, sir.
Yeah, I think what I don't want to do now then is to go into that.
I'm not planning to, and that's where I was going to stop, sir.
From the statement of common ground, I can see that is contested, and certainly there's a view either way. But what I'd like to do is to look at what the impact of that footpath might have on this development next now, because I can see that there's a strong disagreement between Kent County Council and the appellant as to the likelihood of this footpath actually getting confirmed.
Yes,
the order being confirmed, but
yeah,
but anyway, so what I'll do next is in terms of the route. I mean, there's several things that can. Sorry, is there anything else you'd like to say, Mr. Ross, before I move back to Kent County Council? Really, it's Mr.
Well, no,
President.
I mean, you've asked Kent County Council, sir, about the impact, and the plans appended to my Appendix G demonstrate that the footpath can be accommodated if the footpath is confirmed on its current alignment as proposed by Kent County Council. The master plan demonstrates that that footpath can be accommodated at the widths as pointed out by Mr. White on the site. And I don't think there's any, and therefore there will be no obstruction to the footpath or any other matter. That footpath can be accommodated. The question is,
sorry, can I? Well, right, we're looking at that, and you've got plans that you've put forward in your evidence that show that, haven't you? That your 002 and 003 is that what you're
correct, sir?
Yes. And you're saying that that demonstrates that it can be accommodated.
Yes.
And so, yeah, carry on then. I've got those plans.
I think the question between us is, you know, whether that needs to be shown now, given that element is totally in outline. And that's why the applicant and the appellant has always been resistant to showing that, because as we know, this element is outline, and it's not for your determination as to where this goes. We are looking for the principle of development, not the specific location of the footpath. But what seems to be between us and Kent is more of a, and I think both the landscape witnesses have addressed this, and that's why I really don't want to go over it, is what is going to be the experience along that footpath. And I think Mr. White and Mr. Withercombe have given you evidence on that. Neither myself nor Miss Bezic are landscape witnesses, and we're not going to give you evidence as to that.
No, that's right. I mean, certainly this is being given as a reason for refusal, so it is something that's of concern to the council and Kent County Council. So I do want to explore it in some detail now, but there's certainly a lot that's already been agreed, it seems. But I've got both Mr. Davis and Miss Bezic with their hands up. I know Miss Bezic put her hand up first, but can I ask Mr. Davis first to say what he'd like to before I hand back to Miss Bezic? Mr. Davis, can you just introduce yourself as well, because I'm not totally sure what your role is. Mr. Davis, are you available? Ah, right. Mr. Davis? I can't hear anything. No, I'm having a problem with...
Inspector, I'm just trying to help him.
All right. Okay. Right, Mr. Davis, can you just explain your role in this and what your view is? Or I can't hear you now. I don't know what's going on. I still can't. You've muted and now you're unmuting, but I still can't hear. So there's something wrong there, I'm afraid.
Mr. Davis, you should be able to speak.
He is speaking, but I can't hear anything. I don't know whether anyone else can hear anything.
No, so same with all of us.
I think what Mr. Davis, sorry about this. If you can try and sort that out, I'll hear from Miss Bezic first, and then perhaps go back to you if you can sort that out.
Mr. Davis, if you just exit the inquiry and come back in, hopefully that will clear whatever it is. Sorry to interrupt, Inspector.
In the meantime, I will hear from Miss Bezic as she did have her hand up for quite some time. So, so can you?
Yes, I was going to make the point that whilst the route is shown through the residential area as it is, whereby there is granted no physical obstruction, the route still appears to cut across gardens, parking areas, 5 road crossings are needed. Part of it is on an estate footway. It runs between houses. So for reasons of public user safety and indeed resident safety, we wouldn't see this as acceptable. The public enjoyment of a route is an area that is taken into account, and I would refer that to National Planning Guidance, DEFRA, Rights of Way Circular 109, the guidance that local authorities look at to produce and provide high quality rights of way links and routes. And as such, the process whereby when requested that a route was shown at this stage, and I refer to Mr. Ross's previous statement regarding that it wouldn't necessarily need to be shown at this stage, we firmly believe it does, to be taken into account so that we don't go ahead and in the event that in April at the public inquiry regarding AB 70 the route is confirmed, we would then come back to the applicants with another right of way that has to be incorporated within the site. As we firmly believe that rights do exist, it should be taken into consideration now at this planning stage, and to show a positive incorporation, as I say, on the terms that I've just outlined.
So are you of the opinion that it's not possible for a layout for the number of dwellings that are being proposed, i.e. 145, to actually accommodate this footpath satisfactorily?
I think it would be I think it can be accommodated in the sense that there is room within the development site in the western area. There's areas of green landscape towards the periphery of the site. I don't think that the route as it is shown can be accommodated. It would it would necessitate a diversion of the route once it was confirmed. But I do believe there is opportunity when you have a site that is essentially a blank canvas of open fields, that by working together, which is how we do conduct these cases, we could come up with an acceptable route to all that would fit with the development.
But how much of a problem would a diversion to the route be?
It's something that we have done in the past, and on applications whereby rights of way are directly affected, as this would be if it was a confirmed route. Then we go through a diversion process, which is done again, making sure I give my advice so that the application goes through in a timely manner, so the development is not inhibited in any way by any legal process of the diversion.
Right. Okay. So bearing in mind timescales, there would be I mean, even if this was actually approved at this, say I approved it, it wouldn't be approved until, say, the end of next month. Mm-hmm. And then you look at, and that approval then wouldn't, then you'd be pretty close to the inquiry anyway, and then you'd have confirmation, might be the end of April, maybe confirmation, or not, as the case may be. So I would have thought, isn't there sufficient time to be able to work that out anyway?
Absolutely, absolutely, there will be sufficient time. Our point was that it should be considered and shown on the plans, and it was this particular point that, if you like, was the sticking point, whereby the applicant did not show the route of AB 70 on the plans submitted until late December last year. So they have not formed part of the application process, and as such, I believe, therefore, have not been included on the Ashford Planning portal, i.e. therefore available for public sight.
Yeah. I haven't seen anything from Mr. Davis yet, so I'm hoping that he might be able to say something. But I'll
Yes,
hand
I think sorry, sir. I think the idea was that Mr. Davis was going to comment. He's the Ashford Borough Council planning officer, and he was going to comment on the impact on the development as such, from his point of view as the planning officer.
Right. Okay. Thank you. Well, what I'll do is I'll hand over to Mr. Ross and see what his comments are on this. I don't want to go into too much detail because there might be ways of getting out of this problem anyway, but I don't know. But Mr. Ross, actually, before I hand over to Mr. Ross, there's the programme officer who's got something. So can I go to Caroline Williams?
Inspector, Mr. Davis is in the session and is live on camera, and he has his sound unmuted. So I'm sure that if he raises his hand, you can see it.
Yeah, sure. Thank you. Thanks for doing that. Well, in that case, I'll hand over to Mr. Davis and then go to Mr. Ross, really, so that perhaps Mr. Ross will have a chance to do something, say something on both what Ms. Bezic and Mr. Davis will be saying. So, Mr. Davis, I don't know whether you managed to keep. Oh, I've lost you again, Mr. Oh, not doing too well on this.
I've got Mr. Davis on screen, sir.
I haven't.
But also, we can't hear him.
Oh, no. We're not doing too well on this. I'll go to Mr. Ross then, while Mr. Davis is trying to sort himself out. But Mr. Ross, you wanted to say something.
Just two very minor points, and hopefully, extremely so, this can address it. Ms. Bezic has exactly confirmed the position of the appellant. I mean, she has said that the route can be accommodated with no impact, and no, that's exactly what we've been saying. That's exactly what's the words that she said, and she said that it can be accommodated and there can be a diversion. And how we can show a route where we don't even know where the houses go yet at this stage, at an outline stage, is I struggle with. So that's one point. She's clearly confirmed exactly what the appellant has been saying throughout. The route can be accommodated, no impact on the houses. This is something we need to address at a later stage. The second point.
One thing I do need to satisfy myself, though, is I do need to know, because you're looking at 145 dwellings, I need to know what effect that might have on the whole layout, because I need to know roughly where these dwellings are going, i.e. whether it's going to affect vistas or whatever, if you have to move dwellings or remove dwellings on numbers of dwellings, whether you can fit the numbers in that you're proposing satisfactorily. So I do need to have a reasonable idea of how much effect that might have on a layout, and whether it would harm the overall proposal that's being put forward. Because even though it is an outline, I do need a satisfactory scheme that can be put forward to accommodate the numbers of houses, or you restrict the numbers of houses to a number that's actually able to be accommodated within what you've put forward. So I need something more. Yeah.
Well, that's why, sir, that is why in my Appendix G you have two plans showing how you can accommodate the numbers with a footpath. Now, KCC might not like where that footpath goes, but we have to remember that is the width of the footpath, and we are able to demonstrate that you can deliver the scheme with the footpath, including a diversion, and the diversion there is round an ancient tree where currently the footpath goes straight underneath it, and we have looked to betterment in terms of trying to divert the footpath away from it, so there is betterment there. So we are able to demonstrate that the scheme can accommodate it. Now, clearly, if it can be accommodated now, if things do move around, that is all within the parameters of where the site is. If the house moves one area, it's one location, the footpath moves with it, because it's got a defined width. We have been able to demonstrate that the site can accommodate those number of units plus the footpath. And there is no, again, I'm not going to give landscape evidence that's been given by Mr. White and Mr. Withycombe, but I don't think that there's any material difference between the scheme that was provided as part of the application and what is provided to you in my appendices.
Yeah, thank you.
That's the first point. The second point is the point made by Kent County Council about public enjoyment and gardens and parking and houses. And you've been asked by Mr. Withycombe to go to Tenterden Gill and to go to Tent 1A. And you will obviously have a route and you will go to those sites and you will look at the footpaths that KCC have allowed to be diverted. And you will see exactly what KCC have allowed in terms of the diversion and how footpath AB32 and AB36 are accommodated. And I've walked the diverted AB32, which went through fields, and I had to cross the road 4 times in order to keep to it because it continues walking from side to side. It has go through roads. It goes to AB36 goes through a roundabout. So, you know, we're not proposing anything different in what we propose at this stage to what KCC have approved and is common around Tenterden. But clearly, if you grant permission, sir, at the end of March, and if the order is confirmed, let's say at the end of May, clearly the appellant will work with the local authority to develop reserve matters that would provide the best scheme and the best footpath that can be accommodated. You know, I don't see any reason why not. And if the local authority are not happy with that, it is wholly within their gift to refuse the reserve matters. They've got control over this. That is totally within their gift.
Thank you. I don't really want to go into much more detail on this, but I'll let the council first. If Mr. Davies can be heard, I'll let you. No. I'm having a real problem with hearing, and I'm assuming no one else can hear you.
No. We now pay good money to hear Mr. Davis.
That is a shame, but I'll let. No, I'm afraid I'm not doing very well on that. I'll have to hand to Ms. Bezic. I don't really want to go into much more detail on this. Like I say, we have looked at potential concerns about what the appearance might be from the footpath if it were confirmed, i.e., and it seems to be that it could be that as far as I can see, there doesn't seem to be any problem accommodating it or being able to accommodate it. But it's just what it would be like if it were accommodated. Right, I've got Mr. Can I go to Mr. Howell Williams first before I go on to Ms. Bezic? But Mr. Howell Williams, I don't know whether you can explain what's going on or have something, or you've got something.
I can't explain what's going on with Mr. Davies' audio, but I can emphasise the importance of hearing from him on this issue. This is actually a serious issue that's been raised by both authorities. It's common ground that there is an order to be considered in April, by which time there will have been a decision on this application. Assuming the permission is granted, sir, you will appreciate it will have been granted, so far as the west side of the appeal site is concerned, as an outline planning permission with reserve matters to be considered. One of the reserve matters relates to layout. You will also know that at the time of the consideration of reserve matters, no condition can be imposed through that process, either through reserve matters or any other conditional procedure, which fundamentally alters the outline planning permission. And as we intimated in our opening statement, one of the critical concerns here is that the authority should not be put in the position where it is lawfully obliged, legally required at some point to grant reserve matters application for a scheme which has dire consequences on the basis of matters that should have been taken into account at the outline stage. So when Mr. Ross says it's not relevant now, it's not relevant to the principle of development, he's wrong, with great respect. It is entirely relevant. You are legally obliged, sir, to take into account the prospect of a footpath being confirmed. Mr. Ross may continue to shake his head, and Mr. White will no doubt make submissions at the end of the inquiry, but I'm explaining to you what the council's case is in broad terms. We will make legal submissions on it. It is a matter that we believe should be taken into account relating to the principle of development. And the reason for that is twofold. One is because it has implications, potential implications on layout, which are to be determined at the reserve matter stage, which might be very significant because they might pertain to matters relating to the principle. In other words, identifying harm that hasn't been identified at this stage by reference to other plans. And two, because of impacts, for example, landscape and visual impact, which have been touched upon in the evidence of Mr. Withycombe and Mr. Smith, and also because of the implications in terms of the right of way, should it physically be accommodated either on the proposed route or on a diverted route. And what I have in mind there, sir, is that if there is obstruction, there is a means by which a footpath can be diverted. However, there are criteria and considerations to be taken into account on such a diversion application. And Ms. Bezic has already referred to them. In other words, it's not normal to seek to divert and put a footpath on an existing pavement, because legally then it might well pertain to have effect. Well, Mr. Ross is shaking his head again, so I think you need to see the circular, and then it makes it entirely clear. So there are a range of implications, which the council believes should be taken into account at this stage. And I appreciate the appellant's case is that it's irrelevant to your consideration. Submissions will be made, but I hope in broad terms that's an outline of our case, by reference, of course, to paragraph 12 of our opening. But it's in relation to those implications at the reserve matter stage that it's really important that you hear the evidence from Mr. Davies, who is likely, has been involved in this case and is likely to continue to be involved in this case, bearing in mind its importance. And sadly, we seem to have lost sight of him at the moment.
Well, yeah. I mean, Mr. White's got his hand up, but I would like to see whether I can get hold of Mr. Davies actually verbally. Is Mr. Davies available? Because not really. It's a bit awkward, this one.
While we're waiting for Mr. I mean, it's quite clear wherever Mr. Davies is, it's not working, frankly. So he needs to take steps to find somewhere where we can hear him, because he's tried about 7 times. I completely agree with Mr. Howell Williams. We must hear from Mr. Davies, but can I just make 2 points while we wait for Mr. Davies's return, sir? And are you happy for me to fill the gap? So just briefly for 2 minutes?
Yeah, yes, you might, yeah. Yes,
everything Mr. Howell Williams said to you, sir, was a submission, as of course, whenever we contribute in a roundtable, and Mr. Howell Williams can set up all those points which he believes are correct in submissions, and I will take the counterpoint. The only point I'd stress to you, which no one has answered, we saw yesterday the approach that the council took in relation to Tent 1, and it exactly replicates what Mr. Ross has said. So frankly, what the council are doing now, it's completely expedient, this position of objection now, that somehow this site is different or special, or the approach you must take must be different. The council at Tent 1 accepted that the layout which was before them blocked the existing footpath, the lawful footpath, and yet they took the view that the imposition of a condition could deal with the point. And what Mr. Ross says is completely compatible with that approach, which was taken previously in 2014. And as far as I know, and unless Mr. Al Williams tells us, the law relating to footpaths, their diversion, and the law relating to outline consents and reserved matters was identical in 2014 as it is now. Thank you.
Yeah, right, thank you. Right, I'll I've got Mr.
So
Howell
could
Williams.
I comment? Sorry.
I'll just let Mr. Howell Williams respond to that, and then I'll come back to you, Ms. Bezic. But
Okay.
there seems to be something on. I mean, I'm happy to take submissions on this anyway from the two advocates, but
well, so I think this is perhaps not the time to hear our formal submissions, but obviously we need to assist you at this stage. And at this stage, the important thing that we wish to emphasize is that you must hear the evidence which is relevant at this stage of the implications of the order. Mr. White has referred to Tent 1, and you will recall the paragraph in the report that I referred the inquiry to, he having referred to the report elsewhere in evidence before. At that stage, there was a plan showing the impacts, which was taken into consideration, and the implications of it were considered. Late plans, notwithstanding the appellant's insistence that the matter is not relevant, the appellants have, at a very late stage, produced plans for you to consider, I think on the 21st of December, shortly before Christmas Day. So you do have a plan, in fact you have two, in which the appellants say it can be accommodated, but that's not the end of the matter. Indeed, it's the start of the matter, because those plans allow you to take into account the implications on the layout, which might affect questions of principle, by reference, for example, to the landscape impacts on the public right-of-way, and by reference to potential implications on layout, and by reference to potential implications on the diversion rights of way and meeting considerations taken into account when a diversion order is made. So in those three respects, you now do have a plan, which is the appellant's best case. They say it can physically be accommodated, and you have to now consider the implications of those plans in those three particular respects.
right. Can I just try Mr. Davis again before I move on to, because he's got his hand up and he's going to have another go. So,
right, hello. Can you hear me?
Mr. Davis?
Hello?
Mr. Davis, we can hear you.
Can you hear
Mr.
me?
Davis, we can hear you. Can you put your camera on for us?
Yes, I'm trying to do that.
If it's necessary to take your camera off.
It says you cannot start because the host has stopped it.
If you could carry on speaking, we'll get your camera working.
Yes, thank you.
Right,
I just
Mr. Davis, then.
right.
Well,
sorry about the technical problems on that. Just explain. I'm Mark Davis. I'm Ashby Council Plan Department Major Sites team. I was the planning case officer for this application, so I have intimate knowledge of it. So I didn't obviously follow all of the conversations because of the technical problems there, but just from my point of view, in terms of the impact on the layout, the first thing, the revised plans that were submitted just before Christmas in December, they actually do show obviously some changes to the layout, including it appears in one of the so-called development areas or development pods. There's a series of obviously development pods there, seems to be cut back in terms of size. That's the there's three that appear to be affected. The northwest one appears to be cut back, and there's a row of houses being moved back with the road, so it appears to be a smaller area in size. On that, it goes through two other of these development areas on that, where they've obviously changed the layout to accommodate it. I think the first thing, the there was no really explanation of the impact of the changes but provided with the revised route. The application obviously was accompanied by additional plans, such as a developable area, a plan which shows shaded where the residential development areas, the landscaping areas, whatever. That wasn't updated. In the DNA statement, they've gone into some degree of detail in terms of showing the scale, the form of the units shown in the shown on the existing illustrative plan, the mix of the tenures, parking, road hierarchy, and there's also additional drainage plans, which are again to do a degree of detail, even though that will be illustrative. Kent County Council flooding will be basing any reserve matters on those illustrative details on that. So like I said, there was no actually explanation as to, or detailed explanation as to the implication of those changes. If you're obviously going to cut back on part of the development, obviously that's going to have an impact on unit sizes, potentially proposed typologies on that. The other point is obviously the in terms of what Kate advised, the route as proposed at present, mine is really goes right through the residential development area on that. It will have a very significant impact on the spatial implications of the site, because if you have a route through a residential area right through the heart of it, any reserve matters application, you would have to take into account the route and address that route. Now, normally you have a analysis of the site, constraints and opportunities. The public right of way would obviously be an opportunity, but it's also a constraint because you shouldn't be building over it. Well, you'd look to change the layout in terms of to have, for example, active frontages overlooking it in terms of safety. You wouldn't want, for example, footpaths going to the rear of houses, the back of houses where they're not overlooked very well. That increases risk of crime and graffiti. And if you look at the route that is proposed on the revised scheme, obviously there are issues. It goes very close to some of the dwellings. It seems to cut off some of the dwellings rear gardens. It goes through parking and access points, so it's not a particularly a great route in terms of the experience to go through. And the second thing you would have to look at obviously is the privacy of the dwellings themselves. You don't want to have rights of way going right by people's houses in this type of location. You would, in terms of security, you'd want normally some type of semi-private space in between, whatever, so it may be overlooked, the actual footpath, but there's a degree of security for the dwelling owners on that. So my understanding, speaking to Kate, we did ask for this footpath route to be shown during the course of the application on that, because at present we don't think that route through the actual site is acceptable in principle, because it's going right through the middle of the development site, irrespective that obviously you could have a reserve matter application. The layout obviously could obviously reflect that on that, but it will have a significant effect, by the way, on typologies and the mix of houses. At present, we've got over 31 flats nearby. I suspect you're going to have to change some of the typologies which are currently envisaged. And like I think Mr. Howell said, the application illustrative plans only show 141 dwellings, not the 145 they are applying to. So my understanding is that what we were looking for was an alternative route to be shown, possibly on the outside of the development, which would be much better in terms of amenity. Again, there's a lot of things going around on the outside in terms of suds, ponds and things like that, and we thought it was perfectly reasonable for us to explore that at this stage to try and get something in principle agreed, and it's for them, the applicant, actually to show this route on that. Like I said, the route going through right through the middle of a residential estate really, we don't think is acceptable. It will have significant spatial implications when they get to the reserve matters on that. They'll in terms of the built form as well, because you'll need to address it. So that was the reason we asked for it. We thought it was perfectly reasonable request on that. Otherwise, we will be dealing with this at the reserve matter stage, which will be a potential big headache on that. They'll have to change a lot of the typologies they're showing at present.
Right, thank you, Mr. Davis. So I'll just hand over to Ms. Bezic, and then I'll ask the appellant if they want to reply to this. So, Ms. Bezic.
Thank you, sir. I would just like to point out regarding 1001 and AB 32, as it's, this will be very brief, but as it has been brought up, I would like to address it from our point of view. The two sites are not comparable. 1001 is far more urban setting originally, with a much greater housing density, 250 houses plus a supermarket on a much smaller area. Prior to any development, AB 32 was a tarmac surface running across scrubland. On the site itself, there was very little green space available with which to consider a diversion, and equally that green space was, I gather, suffering the constraints of a badger habitat. We take every site on its merits. Our ask is consistent, and as again has just been referenced, the actual policies and legal framework is the same, as is our ask. However, the constraints and indeed opportunities of each site are individual. We look for the best that can be achieved, and in this case, with open fields and, as I said before, essentially a blank drawing board of a new development, there is ample opportunity to provide a high quality, attractive and safe to use route. I also feel that you cannot judge 2022 requirements the same as that of 2014. And again, this is a point that has been touched on in previous sessions. In that time, the pressure on public rights of way and indeed local authorities to provide high quality routes with positive outcomes has grown. And this has come from central government down. The emphasis on quality walking and cycling as both active travel and leisure routes is currently unprecedented. This is reflected in updates of national planning policies, government guidance, local authority, local plans, Kent County Council Rights of Way Improvement Plan, published just in 2018, and indeed documents such as the Kent Design Guide. I'd just like to make those comments, as I say, because I feel that that's important in reflection of how it's been touched upon.
Yeah, thank you.
Thank you.
Thank you. I don't want to dwell on this too much longer, because this can be put in closings and other submissions as well. Because there's a couple of points. One is about this confirmation of the order. Two is how much extent should the footpath be taken on board, and these are all in dispute. And the other one matter is obviously whether it can be accommodated and on the development, and how and what that impact of the accommodating it would have on the development and the decision that I will be making. So all of those matters need to be dealt with. But Mr. Ross, you've got something. Have you got something you'd like to say?
Just a very concluding remark. I wholly endorse what Ms. Bezic said. Ample opportunity for a safe route on this site. Totally agree.
Right. In that case, I don't think we can explore it any more detail. I can have a look on site around this area if I'm allowed to, if I get access to it, and look roughly where that route is and how it is at the moment. But anyway, so what I'll do then in that case, I'm happy to say that this round table is complete. Is there anything that anyone wants to raise before I stop the discussion on this matter? So, Mr. Davis, yeah.
Yes, just briefly. Can you hear me?
Yeah, yes, I can, and I can see you as well.
Right, thank you on that.
It's quite a bit of a change, but
yes,
that's
okay. Thank you for that. Just briefly on that plan, the additional 002 and 003, they are not part of the drawings that have been submitted for determination in terms of sort of the agreed list. And as I said, there is a change. There's a to the plans. There is a cutback on one of the development areas on that. So just to explain that.
Yeah,
That
yeah. I think you did explain that there were changes to. I mean, to be fair, I did try and look at them, and they weren't that obvious, some of the changes, but certainly I'll take your word for it, and I'm sure that there are some changes. Otherwise, they wouldn't have. The appellant wouldn't have actually put forward new plans.
It was a point that they were actually cutting back the development area with a bit on that.
And I'll take your. I think the appellant agrees that there's 141 dwellings shown, and that's the case, isn't it? 141 on both of these plans are shown.
Yeah.
And I think that's not in dispute.
Yeah. But I can send a written just to show you whatever and copy it to the appellant if you need any further confirmation on that. So.
No, I think that's the case, and I don't think there's any dispute. And I think that might be the case with all the plans, but I haven't really got confirmation that all the plans show 141.
I think I did attempt to give you that confirmation, sir.
Yeah. I know you said that, but I'm just saying. So that is exactly correct. There isn't a plan that shows 145 dwellings that's been put forward to this. All right.
Yeah. No.
Right. Thank you. So in that case, what I'll do is I'll have a short break again, and then I'd like to start the sports one before lunch. So I'll adjourn briefly until 12:30. So just to get everyone sorted and get all the material up and everything. So I'll adjourn until 12:30, and then then we'll start the sports round table. Right. Thank you. So the inquiry's adjourned.